Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's Knowledge November session, I'm talking about data protection subject access requests and specifically the response to the request. So we've done our searching and we've got our data. What are we going to need to do to respond to the individual's request, making sure we do it obviously within 40 days? Well, the first thing our response needs to do is confirm that we are a data controller, that we have been processing data in respect of the individual, and describe what that data is and what we've been processing it for. So, for example, that might be email. We then have to give the individual a legible copy of that data. So that can mean extensive printing out of documentation. But you could, for example, agree with somebody that you will put something on a disk and send it to them that way if they're happy to receive it in that way, obviously if they can play that disk. But before we do that, we've probably got to apply some filtering to the data that we've got. And this is why in previous sessions I've talked about this all taking quite a lot of time and you need to get on with it in terms of the 40 days that you have to answer. So the first question is the data that we've got in front of us actually personal data? And traditionally, we've always thought about personal data being biographical or about the person. So, for example, if it's an email, are they the subject matter of that email? But in recent times, the case law really has been influenced by a European opinion that was given that suggests it's actually far broader than perhaps here in the UK traditionally us lawyers thought about it in terms of that sort of biographical link with somebody. So is it linked with them? Is it obviously connected with them in some way? So probably just because somebody was on the circulation list for an email, for example, doesn't mean it's personal data. But if it's talking about them, then yes, it would be. And it's specifically written into the legislation that an expression of opinion about somebody is caught. And this is one area where I think line managers just don't realise that when they are, for example, committing to email their thoughts about an individual, that it can come back to bite them later on if that person makes a subject access request and they see then what that manager has said about them. The second filter that we need to apply to the data is whether or not we need to redact any aspects of that data that actually relate to personal data about somebody else, or third party's personal data. So if an email is about two different people, obviously we want to redact the parts of the email that don't relate to our person that we're dealing with. And when I say redact, that means blacking out. So I have spent lots and lots of time with a black mark pen over the years, literally going through and making sure that you can't read from either side of the paper information about somebody else. The third filter is whether actually or not there's an exemption that applies, and there are 4 different exemptions within the Act. The first is legal professional privilege. So if you have taken legal advice and it's that legal advice that you're exempt from disclosing, obviously that doesn't apply to, for example, HR advice. If you've taken advice internally from, for example, an independent HR person, that is not going to fall within an exemption, only advice from the lawyer. The second exemption is anything in relation to negotiations where it could prejudice the negotiation if you were to disclose the data. So the most common example for an employment law context would be a settlement agreement. If you're midway through negotiations, then it could prejudice the outcome of those negotiations if you were to have to, for example, disclose emails to more senior management, perhaps getting permission to budget a certain amount or something like that. The third example of an exemption is in relation to management, forecasting and planning. So prior to a redundancy exercise kicking off, somebody can't gain access to your plans and the discussions that are perhaps going on internally about how to structure that exercise or how to restructure the business, if it would prejudice then the exercise, perhaps by leaking out information too early. Once you have kicked off that exercise and perhaps an individual's been selected, then potentially you really should be disclosing historical information if you've talked about them in emails. So again, managers need to be aware that if they are talking about perhaps their intentions in respect of somebody, I am going to discipline this person, I am going to make this person redundant, that could all come out in the wash if somebody makes a subject access request. The fourth exemption then relates to references that you have given. So if you've, given the college a reference in respect of an apprentice, they cannot access that in a subject access request from you. But what they can do is go to the college and make a subject access request that end. So for example, if you've got references on personnel files that you've received from former employers of an individual, then they can access those from you, which again is why it's important that you train line managers that when they're giving references to understand that it might be marked private and confidential, but actually, don't write anything you're not prepared to show the individual because they could get to see it long term. That's the end of today's session. The last session will focus on enforcement and some of the practical issues around subject access requests. I look forward to seeing you then.